Hello, and welcome to today's Bloomberg BNA webinar titled New Year, New Hire, Pre-Hire Readiness in 2017. I have just a couple of announcements before we begin. Questions will not be submitted by telephone. Questions may be submitted at any time via the Q&A pod at the lower right of your screen. Simply type your question and click the icon to the right to submit. Questions will be allowed to accumulate and will be addressed towards the end of the presentation or when our speakers deem appropriate. You will currently see instructions on how to earn credits for attending today's webinar. If you have any questions about continuing education credits, please email us at credits@bna.com. In order to obtain HRCI SHRM credits for attending today's presentation, you must answer all polling questions that are presented throughout the webinar. There is no submit button for multiple choice questions. Your certificates will be ready to download in your classroom at learning.bna.com in the My Certificates tab, generally within 1 business day of the presentation. Instructions for downloading your certificate can also be found in the Files pod. A copy of the presentation you're about to see is available for you to download from the Files pod to the right of your screen. We would like to give a big thank you to myStaffingPro for sponsoring today's webinar. myStaffingPro, a full-featured SaaS applicant tracking system, provides HR professionals with the tools they need to recruit, qualify, and track applicants to help hire the best employees. myStaffingPro delivers the hiring process for more than 700 companies and has processed more than 20 million applicants. I would now like to introduce today's speakers. Tanya Bovee is the Office Managing Principal of Jackson Lewis's Hartford, Connecticut office. Tanya helps employers resolve employment disputes and handle personal matters, including disability leave management. She regularly trains employers, and she also has active litigation practice defending employers from federal and state claims. Tanya also defends employers in OFCCP compliance reviews and oversees the preparation of affirmative action plans for employers around the country. Grant McClellan has worked in the HR outsourcing industry for the last 5 years. During this time, he specialized in consulting with clients of all sizes regarding employment law compliance and HR best practices. Grant earned his Bachelor's of Science in Industrial and Labor Relations from Cornell University and is a member of the Society for Human Resource Management. Jessica Hubbard-Davis is an HR consultant with Paychex HR Solutions based in Rochester, New York. Her HR professional experience is focused in both internal and external HR management, and she has worked with clients in various industries and sizes. Jessica has a bachelor's degree in business management from the University of Phoenix, is PHR and SHRM certified, as well as a notary public. I would now like to turn the presentation over to Ms. Jessica Hubbard-Davis.
I wanted to start out by informing you that this seminar is for general information purposes only and should not be considered legal advice or interpreted as legal opinion of any specific facts or circumstances. If you do require any legal or accounting advice or need other professional assistance, you should consult a professional advisor to discuss your particular facts and circumstances. So with that being said, running a business can be costly, as we all know. The trick is to mitigate unnecessary costs as much as possible. One of the best ways to do this is to hire the right individual from the beginning. So why does hiring the right person save money? Well, did you know that the approximate cost of turnover to a single position is around 1.5 times that position's annual salary? Think about this. You spend time creating a position. You post it, you interview, you hire, you train, and you hope that all falls into place. But what if it doesn't work out? You now have to terminate and start all over. Outside of potential unemployment claims and overtime hours to pick up the slack, you are wasting time, and we all know that time is money. Not to mention the burden on your current employees and the diminishing morale associated that can be costly in its own right. So what can you do, and what are some of the best practices to put into place to aid you in this process? That is what we're here to talk about today. Best hiring practices. Our goal is to provide you tips and tricks, do's and don'ts, as well as other things to consider when it comes to starting the hiring process through interview and selection and ultimately hiring the ideal candidate. Please note that for the purpose of this presentation, we are reviewing the following information at a federal level. In some cases, the state and local laws may differ, so please consult with an attorney or an HR professional for more specifics on your particular situation. Also, as mentioned, we will have a Q&A period at the end of the seminar, so if you think of anything that you'd like further information or details on, Don't forget to write it down, and we'll do our best to get to the questions at the end. So during this training, we're specifically going to discuss the benefits of effective hiring practices, identify essential steps and best practices for an effective hiring process, discuss how to implement an effective recruitment strategy, and identify the federal employment laws that may affect the way employees are hired. So, effective hiring practices may help employers. How so? Well, we kind of touched on some of these. Increasing productivity and morale. Those are huge when it comes to the workplace. You want to make sure that you've got individuals who can hit the ground running or with minimal training if necessary. You want to make sure they have the skills that are going to put the business in the best position. You want to decrease turnover. You want to make sure that the individual who's going to be there is going to be there for the long haul because you are investing so much time and energy into them, and reduce as much legal risk and cost as possible.
So Jessica mentioned the importance of reducing legal risks and costs. One of the critical ways to do so is to avoid a discrimination claim. In order to do that, employers want to avoid directly inquiring about or indirectly asking questions at any time in the hiring process about the protected categories. As Jessica mentioned, there's federal law as well as state law. There might also be local law which is impacted. This slide includes some of the protected classes, but not all.
So when we start thinking about the hiring process, we have to start from scratch, especially if this is something where you might be a new business or this is a new process, or perhaps the processes that you had in place were not as effective. So starting from the beginning, you want to define the position and advertise to recruit. So if we're looking at a particular position, you want to make sure that you are writing down all of the information that is going to be pertinent to this job, how you see it now, and potentially how you see it several, weeks, months, years down the road. You want to pre-screen applicants. You want to interview the candidate, make a decision and extend an offer, conduct pre-employment background checks, and complete the new hire documentation. So when looking at the first step, we're creating a job description basically. Some instances, people take the posting that they're using and they develop off of that. The job description should be accurate in representing the position. You don't want to put information in there that is not going to be pertinent to the job. Those are going to be your essential functions. Your essential functions should outline what is expected from this position on a daily basis. So whether that be they are expected to complete accurate records of what they're doing throughout the day, the tasks that are involved, that type of thing. You also want to have some non-essential functions on there. Perhaps they support another department in an absence of an employee. So in instances where maybe an administrator of a position would support a receptionist if they are out of the office or if they are overworked. So that would be maybe a non-essential function. So you want to make sure that you're defining those accurately. You want to ensure that the position status is either exempt or non-exempt. Is this going to be an hourly individual? Are they sales and they're commission-based? Are they receiving a set salary on a per pay period basis? You want to make sure that you're outlining all of those tasks. You also want to make sure that the job description is ADA compliant. This would instill putting information in there such as how much sitting, standing, and walking. Is there any special vision requirements, any lifting? Are there tools that they need to have access to that they should be familiar with? Is there training or required to perform these tasks that perhaps they need to be certified? If the position requires driving, do they have a valid driver's license that's for that state? This is the kind of information that you want to make sure that you are putting into this job description so it is accurate as possible so the individual who is reading these job descriptions and these postings and are looking for these positions are understanding what you are going to expect from them. Tanya?
Sorry about that. Many employers spent a lot of time planning for the Department of Labor's overtime final rule. That's a rule that was scheduled to take effect December 1st, 2016. That would have increased minimum salary levels required for an employee to achieve exempt status with the FLSA, and also included automatic increases. But despite all the time that was spent on this, a Texas court issued a nationwide preliminary injunction, and that enjoined the Department of Labor from implementing and enforcing its final rule. This is a decision that has been appealed to the Fifth Circuit. Since the DOL announced its proposed rule, there have also been various bills that have been introduced in Congress to block or delay or slow the salary level increases in the rule. It's questionable as to whether or not President Trump might sign such a law. If he were to do so, that legislation might moot the Texas lawsuit. Alternatively, President Trump could also direct the Department of Labor to abandon its appeal. Or another alternative is that the Department of Labor might rescind the final rule, but would need to follow the Administrative Procedure Act. The question is really how to deal with this when unfortunately we just don't have a crystal ball. There are many employers who have already gone and made the adjustments. Some did that before the Texas court injunction went in place. Others decided to do so anyways just because there is the possibility that if the injunction is overturned, then the final rule could be in effect immediately. And some employers have just decided to wait. The question really for employers depends on their appetite for risk. It's certainly something that could be discussed with an attorney or with an HR professional. Back to the hiring process.
So once we've got our position outlined, we understand what the essential and non-essential functions are. We know what the individual is going to need to do on a daily basis. We need to look at the recruiting process. So you have your posting, or you have your job description and you take portions of it out in order to post for this position. Where are some great resources? Well, you have your traditional websites where LinkedIn is a very big one these days, Career Builder, Monster, those type of things, job boards like Indeed. You also can do company applications, which a lot of times potential applicants will call in, and you can have them come in and fill one out. Newspaper classifieds, I know people use penny savers. Craigslist seems to be on the top of the list for recruiting resources these days. Company open houses, internet job fairs, point-of-sale recruitment. And there's also individuals who we have come across that have reached out to outplacement and employment agencies and also have called for referrals. Individuals who they've worked with in the past and asked if they have anyone who would be interested in this job or would have certain skill sets that might fit. So there's a ton of opportunities for you to be able to find a great candidate out there. So when you're advertising to recruit, you want to make sure that you're posting the position title in the headline of the advertisement. A lot of people use this as a search function, so you want to make sure it's as clear as possible. Sometimes positions have a title that don't necessarily fit the traditional concept of what that position is. So make sure that the position title that is being posted is very clear. Provide specific instructions on how to apply, whether that be a link to a third party to fill out an online application, whether they have to come in and fill one out directly with you guys on paper, or if you guys have a company website that you are directing them to. Just make sure that it's very clear. Again, using clear language and instructions. Identify that your company is an EEO company, that you're equal opportunity. Avoid discriminatory references, and target a broad demographic and geographic area and mix. The reason being is nowadays people tend to travel. They are willing to relocate. People are looking for a change, and you don't want to shorten your pool of applicants by sticking to a specific area. Broaden it. You never know who's willing to relocate or is in the process of relocating, and you might find a phenomenal candidate who happens to be across the country today but in 2 weeks maybe they're coming to your area and they would be a perfect fit. So don't be afraid to target that area and broaden your horizons. You never know what you would get. So now you have your applicant and you've got your resumes, you've got your applications, and you want to go through a pre-screen. So it's always a best practice if someone sends in a resume to have them still complete an application. The reason being is applications should have a signature on the back of the page that states that to the best of their abilities that they're attesting that the information in that application is as accurate as possible. You may have some instances where the months don't necessarily line up because as you know, going back through history, sometimes you tend to forget the exact month you may have started or completed a position, but it would be as close to, their memory as possible. So you want to make sure that you're getting something with that signature on it so you have proof that the information they are providing you is accurate. You want to make sure that you're getting references. You want to review the job description again. Make sure that since the time that you posted it, nothing has changed, whether someone has left another position, maybe this position you're recruiting for is going to need to take on additional responsibilities, or maybe some of the responsibilities aren't pertinent anymore. So make sure that everything is accurate. Then review the resumes to identify qualified candidates. So obviously you know that there are instances where individuals will submit an application and hope that maybe they get an interview with you to try to put themselves in that pool. You can go through, make sure that the resumes are actually lining up with what you are looking for in that position.
So a little bit about social media. Many employers are using social media as part of their pre-screening. With social media, there's just so much information which is available on the internet. It certainly is permissible to use information that an applicant places in the public domain, and there certainly are advantages. You may get information about an applicant that is highly relevant. So for example, something that contradicts or verifies information that the applicant has already provided. And alternatively, there are also drawbacks. You could also learn information about a protected class, for example, a disability, or perhaps learning that an applicant is pregnant, that is prohibited for use in hiring decisions, and something that may not have come up at all on either an employment application or resume or even in an interview. So as a result, some companies do not use social media as part of their recruiting process.
Okay, so we have posted for our position, we've gotten some applications in, we've screened those applications or resumes against the job description, and we've made a selection of a handful of applicants that you're interested in learning a little bit more about. So the first step would generally be to do a telephone screening. Again, going back to what I was mentioning before, time is money. You don't always have an opportunity to have someone come in and sit down and do full-blown multi-level interviews in order to find someone. You want to kind of screen them out if possible. So whether you have in your process multiple levels of individuals who are doing training, or you just want to have both levels done by yourself, that's fine. But having a telephone screening is a great way to kind of get a first idea of how these individuals are answering some of the pertinent questions that might be deal breakers for you in the end. So you want to make sure that when doing the interview process, and we will go into some of this a little bit later, that you're asking the same questions of each candidate so you can compare later. It's really great to have a list of questions pertinent to the job, the past history, why they're interested, those type of things that you're asking every single candidate every time you talk to them. This way, when you're going through and you're sitting down and you have your list of applicants, you can see how each one answered and scored them accordingly. You want to make sure that the call is about 10 to 15 minutes. This is just a phone screen. This isn't a full-fledged interview. This is just a way to kind of narrow down your applicant pool. Avoid any inquiries that may seem neutral but could screen out or discriminate against members of a protected class, as Tanya had alluded to earlier. Make sure all inquiries made during the telephone screen are permissible pre-employment inquiries. And again, we will go over a list of some do's and don'ts a little bit further in the presentation. And do not write notes directly on an employment application or resume. Applications and resumes can be used in court. So if for any reason an individual filed a claim for whatever reason and this application or this resume was called into court, your notes would be admissible. So you want to make sure that you are taking your notes on a separate sheet of paper that is specifically being used for the interview process. So conducting structured interviews. So now you've gone through your phone screen and you've narrowed down even further your applicant pool. So now you want to see who is going to be doing the interview process. Again, you have your pre-screen. Now are you going to have a first level supervisor do an initial interview? Is this going to be the final interview? You want to have that outlined. You want to know who's going to be conducting them and where they're going to be held, because you want to make sure that the interviews are held in a quiet location that you're not going to have much disruption, if any. Review the resumes and job descriptions before the interview. Ask the job-related open-ended questions. Try to avoid asking too many yes-no questions, because you cannot get as much information as you could if you asked an open-ended question that required them to divulge a little bit more information. Again, do not write notes directly on the employment application or resume. Never make any promises. You don't want to get stuck into a situation where someone said, oh, well, they promised me a job, or they said that I would hear back in 24 hours. And in our case, we're in the middle of a snowstorm, and it might not have been as easy for us to call back in 24 hours. So never make promises. Inform the candidate of the next steps. Okay, you've been through your phone screen. You are now on a first level interview. The way we do this is we have a second level interview or a final interview if you make that list, and we move you on to the next one. You will be hearing from us shortly, something to that effect. Give them an idea of what to look forward to. And evaluate each candidate after the interview. So go back through your notes while the information is fresh in your mind and jot down anything else. Perhaps the way that you noticed that they were interviewing, how their demeanor was, how they answered the questions, were they in a great mood, did they seem super enthusiastic? Make notes about those things. You never know how it's going to come back and affect your decision at the end. Okay, so things you can ask a candidate in an interview. It's not to say that this is all-inclusive, but just some really good do's and don'ts. So why did you leave your previous job? What are your references? What is your work schedule? Perhaps you offer flexible work schedule. Perhaps the position that you're looking for, it has a very strict work schedule that cannot deviate at this point in time. And you need to know that the person can only work from midnight till 6 a.m. and that doesn't work for you. So don't be afraid to ask those questions. Previous work experience or about a previous employer. It could or could not be relevant. Perhaps they're taking a career jump and they're trying something new. You never know, but you might find something that you are looking for this position to be in the future come from their past work experience. Career interest, where are they looking to go? Are they looking to grow with the company? Are they wanting to be in management? Are they wanting to just get in the door because it's a great company and hope to go someplace else with the company? Job duties and training. Do they have any prior certifications? Do they have anything that they've done in their past that might work for the position now or something that you could see in the future? Education or qualifications related to the position and any job-related professional association. Things you should never ask a candidate. This goes back to the list that Tanya was speaking about earlier with some of the protected classes. So you never want to ask about an age, a date of birth, the race, religion, sex. Never ask about a candidate about their marital status or how many children that they have. Previous addresses or status of living arrangements. It's not pertinent to the position, so it's not appropriate to ask. Loans, financial obligations, wage attachments, or personal bankruptcies. You never want to ask anything financial. If there is something that is pertinent to the job, if it is very specific to what the position is going to be doing, then those are situations where you may want to ask for legal counsel to see if there is a background check that would find out the information that you need to know that would be appropriate. Arrests or convictions or disabilities, past injuries, or diseases.
So let's talk about convictions and arrests. Ban the box is a hot topic these days. The Ban the Box movement has ground traction across the United States. What is this box? It's the criminal conviction inquiry on the application. So if you look at the question that's on the slide, that generally is similar to what many employers in the past have included as part of their application. Banning the box prevents or limits affected employers from asking job applicants about this information, so getting the criminal history on the job application. There are some arguments against the box. There are many, but generally, banning the box provides greater opportunity for applicants with criminal records to be considered on their merits and not immediately disqualified because they checked off yes, they have a criminal conviction. And we know that based on the numbers, there is also a disparate impact on minorities in regards to convictions. For the arguments in regards to the box, there are also many. Oftentimes companies want to know as much as possible about candidates, and they're also looking to make decisions quickly on moving forward with candidates to avoid wasting time and resources. As a result, there are a great number of employers who feel that keeping the box is helpful to them. It helps them weed through the candidates in a very quick way. This is an area of the law that has just been rapidly changing. It's a patchwork of a variety of laws. Certainly, it's difficult for employers who are recruiting on a national basis just because there are so many different state laws as well as local jurisdictions. We're not going to go through it, but within the slide deck, you can see that we have listed the states where the box has been banned, as well as where the municipalities have banned the box. In addition, there is also the EEOC guidance that was updated in 2012. The update we look at as signifying the EEOC's interest in this topic. And indeed, the EEOC is discouraging employers from using blanket exclusions of individuals who have been convicted of crimes. And the reason for that is, as I mentioned earlier, the disparate impact on individuals who are minorities. The EEOC guidance provides a best practice. The EEOC recommends conducting a targeted screen, so looking for job relatedness, as well as an individualized assessment. The targeted screen is pretty simple. It basically just requires that different standards be used for different positions and making sure that employers are avoiding automatic exclusions. In regards to the individualized assessment, that involves having a dialogue with the applicant in order to do the individualized assessment. And the guidance provides 9 possible topics of consideration, which are listed on this slide. So from a best practice, the best practice to comply with multiple jurisdictions is to simply inquire post-offer only. Otherwise, if an employer wants to be more aggressive in asking about conviction information, the employer would need to make sure that they are up to date as far as all of the various laws that might apply. Another best practice is making sure that you have updated forms as well as processes, making sure that you're engaging in the EEOC guidance's best practices, which is conducting the targeted screens and engaging in the individualized assessment before denying someone employment. The other thing that Jessica had mentioned was arrests. Well, what about arrests? You know, the arrest as opposed to the underlying conduct should not be considered in making employment decisions. When we talked about ban the box only included conviction information. That's different from the arrest. We don't typically see requests for information, and we certainly recommend that requests for information about arrest not be included on employment applications. Having said that, can you ever inquire about an arrest? Well, you can certainly ask about the circumstances of an arrest, and you can make a decision on the underlying facts and circumstances, as well as perhaps the credibility of the individual in their explanation about the arrest. The caveat, of course, is that there are some states that do not allow you to use arrest information at all.
Okay, so the hiring process, we're going to review some of the sample interview questions. So we went through some do's and don'ts. So let's go in and talk about some of the questions that would be great to use when in an interview. These could be the ones that you have a set of questions that you're asking each applicant for the same position. These are the kind of ones that you're going to want to use. So when it's education-based, what courses did you take that you think might be helpful in this particular job? Are you currently enrolled in school? Questions about the position itself. What are your current key responsibilities or objectives? Which of these do you perform best and why? The reason it's good to ask questions like, which of these do you perform the best and why, is to find out where are their strengths. You don't necessarily want to call them weaknesses. However, there are areas that we're not all as strong at, and having this knowledge up front is great. It might be an area for development, for training opportunities, to find out where this individual would be best suited. Which aspects of your position do you like the most and least? Maybe they're very analytical and they'd be great in a data entry, calculating figures type of position, as opposed to maybe they like to be more manual and they want to be out in the field working with their hands. Always great to know kind of where someone is best suited. Job-specific questions. Why are you interested in this position? Which aspects of the position do you feel most and least comfortable with, and which responsibilities would you need training for? It's good to find out where again, they have strengths and weaknesses and where they're looking to develop. Perhaps they're in a position that's more analytical and they want to have a position that is more manual or more customer service oriented. Maybe they're wanting to make a change, so they're going to need training for this, but they're willing to do that because that's where they're passionate. Questions about management experience, if applicable. Describe your management style and how would your subordinates describe you. This won't be applicable in every circumstance unless you are looking for a specific management position. However, it's good to know because you have individuals who are very good at managing down to the very last dotted I and crossed T. And then you have some that are really good at team building, and maybe you have a circumstance where you need more of one versus another. This is a great way to find that information out.
Thanks, Jess. So once we've done our due diligence and we've evaluated through a phone screen some top candidates that we want to bring in for a face-to-face interview, then we've gone ahead and we've followed through on that interview and sat down with the candidates, the next thing we need to do is post-interview follow-up. We need to go back. We need to evaluate the notes that we took during the interview to see if, are we missing any information? Did the answers that the candidate give us really kind of answer the questions that were posed to them and give us the answer that we think is going to make them be a best fit for the role? Best way to kind of do this, to keep track of your notes and to kind of evaluate the candidate and what the responses were during an interview, is by completing an interview evaluation form. A lot of times these are based off of a numeric rating scale that ranges from 1 to 5 or 1 to 10 that allows you as the interviewer to assign a point value to that candidate's response to a question. At the end of the interview, or at the end of going through your interview evaluation form, you go back and you kind of add up those scores to figure out, okay, from a quantitative standpoint, who out of the 3 or 4 candidates I interviewed for the job are giving me the highest scores to the questions that were asked of them. A couple places, if you don't want to start from scratch with an interview evaluation form, something like the Society for Human Resource Management offers templates, and also with your subscription to the Bloomberg BNA service, the online platform has some templates that you can use as well. After reviewing those notes, you want to make sure that the information that the candidate provided is accurate information. Take the responses, compare it back to their resume or to their application. Make sure that time frames kind of line up. You definitely also want to take the time to call out and check any references that were provided, or also call out and check past places of employment to verify employment. Doing so can, A, provide us as the interviewers or as the hiring managers with more information regarding that candidate, and in addition to, it could help prevent or protect us from any claims of negligent hiring. What's negligent hiring? Well, let's say you're interviewing John for a position at your company. And if you called John's past employer, you could have easily found out that John was fired from his past place of employment because he got violent in the workplace. You know, if he punched or strangled a fellow employee or customer or something along those lines. But you didn't do that. You didn't check references on John, or you didn't check past place of employment. John comes into your place of employment and does that same behavior for your place. You could be on the hook for negligent hiring at that point because you didn't do your due diligence in checking out John's references and checking out the past place of employment and maybe why he left jobs previously. Additionally, after checking references and verifying things like key facts, you may want to move ahead with something like pre-employment testing or background checks, which we'll get into a little bit more here. Some employers like to do pre-employment testing as part of the interview or the evaluation process. Pre-employment testing is typically used to find out additional information regarding skills or background that may not come to light during an interview or may not be highlighted on something like a resume. For example, you know, having your candidates, your top candidates, take something like a skills test before offering them the job to figure out whether or not they have the skills to actually do the job. In some cases, some employers, because the employees will be dealing with numbers, will be dealing with math, will be dealing with counting money or something along those lines, may make the candidates take something like a math test, or may make them take something like a driving test, something along those lines. The key here is that pre-employment testing is regulated to a degree by the Americans with Disabilities Act. And what we want to make sure we're doing is that the test that we're making the candidates take actually applies to the job in which we're hiring them for. For example, you know, if you're just hiring someone to show up to the office every day and do something like data entry, it makes no sense to make them take a driving test, all right? And it just isn't pertinent to what they're going to be doing. Likewise, if you're hiring a manual worker, if you're hiring, you know, a lumberjack, something like that, it may not make sense to have them come in and take something like a higher level math test. It just doesn't pertain to the job. In addition to pre-employment testing and making sure that the testing that we're making the candidates do is relevant to the job, we also want to be mindful of what we're actually having them do from a testing standpoint. Having a candidate come into your place of work on a trial basis, quote unquote, where you're just evaluating whether or not they can do the job and they're actually doing revenue generating functions for you, that's an employee at that point in time, and more often than not, you're going to be obligated to pay a person for their time when they're coming in and they're doing revenue-generating functions for the business. So one example that I always use is I was working with a client, employer or client one time that was a dentist's office. And as a part of evaluating his candidates, he would have hygienists come in and actually clean the teeth of some of his patients. Now, this would not be, you know, for compensation. He would not process a W-2 for them. He would not process them as a new hire. He was just bringing them in to see if they could do the job. That raises some major red flags because if the employee were to go file a claim against you, you more than likely would be obligated to pay them the wages. Or if we think about it even a little bit more, let's say that candidate for employment injures a patient or gets hurt while they're there. This is an employee that we're paying things like workers' comp premiums for, so you could have additional implications and liabilities that you could be on the hook for. So again, the big thing with pre-employment testing is just making sure that it's job relevant and that we're not asking our candidates to come in and do revenue generating functions for us until after they've been hired for the job. So we've gone through, we've done our interviews, maybe we've done some pre-employment testing. Now we need to get to step 4 of that 6-step process that Jess was talking to us about at the beginning, and we need to make a hiring decision. Some key questions for reflection when we're evaluating these candidates at the end of the interview process is, did we acquire enough information to make a decision? If not, maybe we need to schedule another interview with these people. Maybe it's just as simple as a follow-up call to them to get some additional information. Do we need to schedule any further interviews? Has our search kind of proved fruitless? Have the people that we brought in not really been qualified for the job, and do we need to go back to the well to see if we can draw some new talent in to evaluate them further? Is the candidate qualified to perform the essential functions of the job? This is where having a well-written job description really comes into play in defining what those essential functions are, because then we can evaluate whether someone has the skill set or the physical capability of actually coming in and performing those essential functions. Does this person appear to be a good fit with the company and the culture? Maybe you have a very small team dynamic that has a very strong culture in place. We want to make sure that if we're bringing or adding a member to that team, that they're going to be a good fit with the coworkers, something along those lines. In that instance, it may be worthwhile to bring in some of the other team members in on interviews to kind of help assess that fit and to get a gauge for that person's personality and whether or not they're going to mesh well. Did references confirm the candidate's qualifications? Again, if we're calling out, we want to make sure that we're calling on those references. We want to make sure that we're checking past employment, all right? And if we're checking on past employment and we're getting feedback that this person actually didn't work here, or we're calling references and they're telling us that, they wouldn't refer this person the job, or they weren't asked by this person to be a reference, that's information that we may want to take into account when evaluating this candidate. And would this person be a good decision for our company? Why or why not? And I think that question, is kind of a culmination of the prior questions that we've asked ourselves to really kind of evaluate whether or not they're going to be a good fit. We want to keep in mind that decisions to hire someone or decisions to not hire someone should be based on objective job-related factors, okay? And again, not taking into account that kind of protected class status that my other colleagues have talked about. So let's look at some valid job-related reasons for not hiring an individual, or some reasons that would shoot up red flags to us when we are evaluating this person's candidacy. Number one, the person's unwilling to work the required hours. That's a pretty big red flag. You as the employer set the wages and conditions of employment, all right? And if you have someone that says, no, I have other obligations where I'm not going to be able to work from 8 to 5 every day, do you have a swing shift I can work? If you don't, and if you're not hiring for that shift, it doesn't make sense to necessarily bring that person in. Maybe this person lacks the necessary or documented job qualifications. Again, you bring them in for an interview, and they're just not giving you the information that you need to feel confident that they're going to be a strong fit for the job, all right? Maybe they fail pre-employment testing or post-offer drug screening, or they fail a background check, which we'll touch a little bit more on in a moment here. If they fail that information, and that's critical that they need to pass in order to do the job, that could be a knockout factor as well. The person's physically unable to perform the essential job functions with or without a reasonable accommodation. Most employers, I would say, are going to have to comply with the Americans with Disabilities Act, which means that regardless if a person has a disability or not, if they can perform the job with or without, and the essential functions of the job with or without a reasonable accommodation, you as the employer are then obligated to work with that candidate or work with that employee, if it's an actual employee of ours, to kind of find out what a reasonable accommodation is. Those accommodations are not always cut and dry, black and white, and they differ based on the employee, based on the cost of the accommodation, and based on the employer. But that's something that we would have to keep in mind as well. Is the person under the working age or lacks the required work permit? Does this person are they coming from out of the country? Do they have the correct permits, work visas to come in and work for us? Do they have the correct information to validate whether they are eligible to work in the United States for us? Or again, are they of working age? Or are we in an industry that has a higher threshold for working age where we can't employ this person because it's too much of a risk? And then the last thing we'd want to take into account if we're going to not hire someone was the information that they provided to us accurate? Again, if you're calling out and you're finding out that this person didn't work at the prior jobs that they listed, or that this person, isn't of the character that they said they were, the references are not backing up the story that they told you during an interview, something like that. Or again, you're going through your interview and the questions you ask, and you're finding kind of discrepancies between their answers and maybe something that was on a resume. Again, these could all be things that are showing you that there's been inaccurate information which was provided, and as such, this person is not fit to perform the job. After we've made a hiring decision on who we're going to move forward with, then we want to extend a job offer, okay? The best practice in this case is to have the hiring manager extend the job offer to that person, the individual that they're going to be reporting to directly. We always want to maybe extend that verbally, but also follow it up in writing when we do follow up with a job offer letter, we want to be mindful that we don't violate our right to employment at will. 49 out of the 50 states in the union operate under this idea of employment at will, that you or the employee can, end that employment at any time without cause or notice, or you can choose to not hire someone. If we're extending a written offer to the employee, we want to make sure that we're doing a couple key things, like stating their wages in terms of an hourly rate, all right, if it's a non-exempt employee, or if it's a exempt or a salaried employee, that we're stating their wages in terms of salary on a per pay period basis. We've seen pitfalls where people throw on there, hey, you're going to make $100,000 this year. And then the person leaves 6 months in to the job, and you may be on the hook for paying them that whole $100,000 because that's what you stated you were going to pay them for the year. We want to make sure that we're not indicating a contract for employment either, and that we're retaining our rights to employment at will, okay? So even verbally saying something like, you're going to have a long, successful career here, or we're going to keep you forever, or something like that. Even simple statements could offer up the verbal contract for employment. So we want to stay away from any promises of, again, salary in yearly terms, or for the employee being employed there for any duration of time. And then also, too, it's always a good idea, if the job offer is contingent on the candidate passing a background check or passing a drug screen, something along those lines, that you make that clear in writing to the candidate as well, so they realize that there's still another step in the process. Now, on to background checks. Similar to the pre-employment testing that we discussed, there are different types that you could ask a candidate to undergo. You have your criminal record checks. You could do something like a Social Security number trace, or a credit check, or a motor vehicle driver history check. The key here is that, A, the check that you're having a candidate go through is based off what they're actually going to be doing in the job. For example, if you are hiring someone to come in and be your CFO, or if you are hiring someone for a banking position or a position where they're going to be handling, large amounts of money or something like that, in that case, a credit check may be appropriate, all right? If you are hiring someone to come in and be a valet for your organization, or you're hiring someone to come in and be a limo driver, then doing something like a motor vehicle history report is also going to be something that would be crucial in evaluating this person's candidacy. There are a couple different laws that I'm going to turn it over to Tanya to talk about in a moment here that come into play when we are issuing background checks, all right? And it's always a best practice to make sure that, we're running those background checks through a third-party agency that, is certified, is licensed to perform those checks, and is going to be compliant with all federal or state laws that may come into play when running those background checks. Tanya, I'll pass it over to you.
Thank you. So we've talked about criminal background checks earlier and the laws that are impacted. Another area that employers might be prohibited from obtaining data on is credit checks. Like criminal background checks, we recommend that employers focus on job relatedness. So is this a position where knowing an applicant's credit history is relevant, and then also doing that individualized assessment. But another thing to be aware of is that there may be a state law which limits an employer from obtaining credit checks. It's important to know the laws for the jurisdictions in which you're recruiting. And I would say that, this list of states, for example, it's a focus on limiting obtaining credit check information. So, for example, I'm in Connecticut, and there was an employer who runs cafes and wanted to know, can we do a credit check on an employee who's not a manager, who works late at night by himself, working in that cafe? When we looked at the law in Connecticut, there are a number of exceptions where employers may run credit reports. One of them is for it being substantially related to the employee's current or potential job, and then also requiring access to the employer's non-financial assets that are valued at $2,005 or more. That's a very non-round number. Interestingly enough, while working with the State Department of Labor, it turns out that they were of the belief that it would be fine for that particular employer to run the credit check. And the reason why was because that employee working alone at night in the cafe had access to the cash register, which was an expensive point-of-sale system, as well as the various coffee machinery, all of which added up to over $2,005. So I say this because if for you in your company, if you feel very strongly that you think that it's important and you're in one of those states where there is a limitation, it would probably be worthwhile for you to work with either an attorney or an HR professional to determine whether or not it's something that in fact you can do. So some other hiring challenges, the Fair Credit Reporting Act, or FCRA. This applies only if you use a consumer reporting agency to get background information. An employer is generally not considered a consumer reporting agency unless it just so happens to be that the employer is in the business of consumer reporting. Some pre-procurement requirements, so basically before the request is made, the employer must be providing certification, disclosure, and notice, as well as obtaining authorization and consent. It's very important to provide clear and conspicuous notice in regards to the applicant's rights, and that's a theme that comes up in every single step under FCRA, that providing that clear and conspicuous notice is crucial. So before taking adverse action, so in other words, before disqualifying the applicants, what needs to be done is notice must be provided, the actual consumer report must be provided, the applicant must be provided with a notification about their rights, and then there's a waiting period. This allows the applicant to contest, to try to explain, or say that perhaps there's a wrong identity. And that has certainly happened. I think, with the rise of identity theft, unfortunately these days, that is becoming a more common occurrence. For post-adverse action requirements, so after taking action, after disqualifying the applicant, again, notice must be provided as well as what the individual's rights are. And to get back to Justice's caveat, which she had made at the beginning of the webinar, just be careful of state requirements. So the Fair Credit Reporting Act that we were talking about is a federal law, but there may also be a state law that applies to this as well.
Okay, thank you, Tanya. So again, now we've gone through those 5 processes of, evaluating these candidates, interviewing them, doing our pre-employment screenings, doing our background checks and the like. We offer employment to this person, so what's the next step after that? There's always new employee documentation that's going to come into play whenever you hire someone. And most states are going to require that you do new hire reporting as well to the applicable state agency that you have hired a new individual. But let's take a look at some record retention guidelines. Records that must be retained for at least a year include public advertisements or notices about job openings, promotions, or training opportunities, job applications, resumes, and replies to job advertisements, job orders that have been submitted to an employment agency or to a labor organization if you're staffing a union workforce. And then also records relating to a refusal to hire, including any kind of those pre-employment tests again, and any kind of failed background checks, drug screens, that type of thing. Once we bring that employee in, though, at the federal level, there's 2 pieces of documentation that you're going to want to make sure you get from every employee. First would be a Form W-4. Now, that's going to let us know, and when we go to file taxes at the end of the year and file an employee's W-2, what the applicable withholdings are for that particular employee. In addition to a W-4, you're also going to want to make sure that you get the Form I-9 completed for each employee that you hire. The Form I-9 is that document from Homeland Security that's going to establish, A, a person's identity, and B, their eligibility to work in the United States. Now, again, keep in mind that these are federal requirements. At the state level, many states have additional state-specific withholding forms that they require you furnish to the employee. In addition to that, a lot of my employers that I work with are in the state of New York. New York has a requirement that you also provide to an employee upon hire something like a wage notice form that declares to them what their wage rate is, the frequency of their pay, and they're required to sign off on that, and you are to keep a copy and they're to keep a copy. So be mindful of your state-specific and local-specific requirements for new hire documents as well. So in summation, these 6 steps that we've talked about today, and there's a lot to talk about. If we are doing our due diligence and we take the time to implement these within our hiring process, the trends show that it's going to lead to a workforce that A, is more inclined to get the job done. They're more intrinsically motivated to come work for us, and they're more willing to stay and stick around, which helps prevent us from potential claims from disgruntled employees, and also those kind of inherent claims of turnover that Jess was kind enough to speak to us about in the beginning. So that concludes the seminar. What we want to do now, it's 55 after, we want to take about the next 10 minutes to answer some of the questions that came in from the audience. Some of the questions are a little specific or state-specific or scenario-specific, so we may stay away from those. If you have any additional questions, please feel free to continue to type those in. And at the end, our contact information will be provided as well if you want to reach out to us directly. So, Tanya, I see if there's a question you want to answer right off the bat. You want to go for it?
Sure. The question is, couldn't the notes, even take on separate paper, be subject to a subpoena anyways, or do we just throw them out after the process? The answer is that, yes, certainly, whatever notes you take, if you keep them, that is something that, should there be any type of litigation in regards to this decision, could be compelled, whether it be by subpoena or just in discovery. Having said that, up until you have a litigation holds notice in place, so you're on notice that there is litigation, and you've put something in place which says do not discard any documentation related to this, you don't have an obligation to actually hold on to those notes. So yes, they could be thrown out. Having said that, one of my thoughts would be we are seeing a rise of failure to hire claims. And as a result, oftentimes having those notes can be very powerful because sometimes, you're making assessments in regards to the candidates who are in front of you. As time passes, you may not remember, particularly where it's not in regards to employees, but it's applicants. So you might actually be talking to a number of applicants and not recall the specific detail. The other piece, of course, is that juries really love paperwork. Without documentation, oftentimes it's hard to convince a jury that someone thought the way that they did at that time. So I see that Grant is going to jump in and answer a question as well.
We had a few questions come in about background checks and the pre-employment screening. One in particular, for positions that require background checks to work with children or other classified groups, is it the responsibility of the company to pay the associated fees? As a best practice, absolutely, you want to be paying for any kind of incurred costs that come with a pre-employment test or with a background test as well. Now, off the top of my head, I can't think of any exemptions to the rule. There could be some things that come into play if you're working with a unionized workforce or something along those lines. But absolutely, whenever you're offering or you're mandating that an employee take a background check, or some type of pre-employment skills test, something along those lines, you want to make sure that you as the employer, the hiring employer, are absorbing the cost of those tests.
And
Jess, you want to jump in?
Jess is going to jump in.
Risk should a candidate be denied position and discovers the aforementioned was used as consideration. There's always that risk. That's why it's very important when interviewing and making sure that the individuals who are part of your interview process, such as other managers or owners, that they're asking the same questions. So that way, if it were called into court and you had to prove as to why you chose one candidate over another, you would have all of the notes asking the same questions to all candidates, their application and their resume in hand to show why one candidate was chosen over another candidate. There will always be that risk, I think, with using social media and Google searches to look up candidates. It's not to say that, it can't necessarily be used. Some states I'm sure will be a little bit stricter on that. But just make sure that you're consistent in how you're performing your interview as to avoid as much issues with that down the road.
This is Tanya. The one thing that I would just add is that another way to try to avoid the risk would be to think about having a person who isn't actually making the decision be the one who's looking at either the Google search or the social media search and filtering what data is passed along to the group. So, for example, if you're looking for someone to confirm, to verify what the applicant says is true, you can have someone look at that, and then they don't necessarily need to share that they had, I don't know, seen that that particular applicant was very involved in their church, for example. And I'm going to pass this along to Grant, who I see is ready to answer a question.
Sure. We had a good one come in. If a candidate has lots of visible body piercings, is it appropriate to ask if the candidate would be willing to remove some piercings should she or he be selected for the position? That's a great question. And it's not one that necessarily has a clear-cut yes or no answer. Definitely, if you have a policy within the workplace that, hey, no visible body piercings, no visible tattoos, for the most part, it's all right for an employer to put something like that in place as a policy within the workplace and to enforce it as such. To my knowledge, as of right now, amongst the states in the union, we don't have too many states that are putting body piercings or tattoos as a protected class at the state level. Now, with that said, there are some implications therein that could kind of be more indicative of why that person may have those body piercings. Perhaps their affiliation with a certain religious sect or religious group necessitates that they have to wear these body piercings or something like that. Well, then we kind of get into a little bit more of a sticky situation. You can always try to work through some accommodation with the employee where if they're willing to remove those, or if they're willing to cover them up and it's a win-win situation for everybody, then so be it. But in some instances, if the employee, for whatever reason, cannot remove those piercings, if it really doesn't pertain to the duties of the role, maybe we want to extend a religious accommodation to them, to this employee in particular, because of their religious beliefs or their creed or whatever it may be, to allow them to continue to wear those piercings within the workplace. And with that, I'm going to pass it back over to my colleague, Jess.
Well, thank you, sir. Another good question. What about driving record? Can this be reviewed? Yes, if it's pertinent to the position, if you have someone who is working in a mailroom and they never leave the mailroom and they don't drive for the company at all, there really wouldn't be any reason to go over their driving record. Perhaps they don't drive at all and they don't have a valid license in the state. They take the bus everywhere. If it's not pertinent to the job, there would really be no reason to review a driving record. However, if the job requires, I know we've worked with some employers in the past where they have technicians that drive company vehicles and they have to be insured by that company to use the vehicles, it would make absolute sense to make sure that that individual has a clean driving record and is able to be put on the insurance to drive for the company for that specific position. So, yes, in those instances, it would be absolutely appropriate. Ms. Tanya?
Okay, so we received a question, which is actually the very first question that we got, which is with regard to pre-employment background checks. What about the ban the box rule with regard to reentrance? I presume that that's a question where someone worked for the company, had provided information in regards to their conviction, and now is reapplying again. So assuming that they answered the criminal conviction inquiry the first time around, can you ask it again on the second in a state or a municipality where there is ban the box in effect? And the answer would be no, because it would be the current law that would apply. I guess the more challenging question would be, can you consider a candidate saying, yes, they had been convicted when they answer the question on their first stint of employment and considering them for employment for the second time? And I would say that the answer is no. I mean, I guess I would question, first of all, is it a different role? Is there a reason for why it is that the conviction would make a difference now versus then? And then alternatively, I think it's, again, important to make sure that not only are you doing that targeted screen, so looking for the job relatedness, but also doing the individualized assessment. So not knocking this candidate out simply because they had checked off the box previously. All right. And I think we have one more question.
Yep, I think I'll take the last one. I know we're getting short on time. With regards to evaluating a candidate, who should be involved in this process, especially if the department person is not part of the interview? I think I'm reading that right. If I butchered your question, I apologize. So when setting up the process as who's going to be doing the interviews, it definitely depends on the size of your business. Do you have multiple layers? Are you a very large organization that has supervisors and then managers and then CFOs, CEOs, owners, that type of thing? Or are you smaller and you maybe have a front line and an owner type of situation? So once you establish kind of what your structure is going to be, you really want to have the people interviewing for the position be pertinent to that position. So if you have an HR department, maybe making them a first line to kind of help screen out some of the candidates, and then maybe having the supervisor and or manager of that department interviewing them would be a great idea, because then they're going to know who's going to work well in that team. They know that position better than anybody, other than the employees themselves working the position. So having someone who has knowledge of the position, who is going to understand how and what skills are going to work best with that team and to get the job done, those would be the individuals you really want to have in the interview process. If you don't have as many multiple layers, you don't have an HR person, maybe you just have an admin person who's acting as an HR person, that might not be necessarily your best bet. You might want to go right to the individual who is going to be supervising and or an owner to evaluate that position and the qualifications from the candidate. I think that was it, you guys.
So on that note, if there are any questions that we didn't get to, on the slide that's up, you can see our contact information and our emails. Otherwise, thank you so much for joining the presentation.
Thank you, everybody.
Paul.
Great. Thank you so much for your presentation. I hope that everyone found today's discussion to be helpful and insightful. You can register for future Bloomberg BNA webinars by accessing our store at www.bna.com/learning. You will currently see instructions on how to earn credit towards attending today's webinar. Please go to learning.bna.com to retrieve your certificate. Please allow one business day for your certificates to appear. If you have any questions about continuing education credits, please email us at credits@bna.com. Finally, I want to again thank myStaffingPro and our speakers for putting together today's presentation. Thank you very much for your participation, and enjoy the rest of your day.